This one annulment, I'll be very quick because I know unless people have questions. This one is, this is about non-consummation, the basis of non-consummation. And the husband agreed. So the parties had been married in a civil ceremony, but they delayed consummation until they could have a proper Sikh Gurdwara ceremony that according to their culture and religion was necessary. That's what the court says. And this is what the wife testified to. Anyway, that ceremony didn't happen. And prior to that, there was the husband had some mental health issues, depression issues, there's fighting, so they separated. And so the religious ceremony never took place. She wanted an annulment. The Chambers judge says no, denied the annulment because it didn't meet that test of non-consummation, psychologically incapacity, right? The Court of Appeal said, hey, we're in a multicultural society and our common law principles must be applied contextually in accordance with the cultural norms of a party seeking the annulment. So the Court of Appeal said a psychological incapacity can arise as meaningfully from a sincerely held religious and cultural beliefs as from other forms of psychological aversion, both being contextually a normal, predictable reaction. The court said a true aversion to consummate arising from religious beliefs established a genuine psychological incapacity. So the court says it would have helped, though, if there were in the future, here's a hint, if you're ever trying to do annulment on this ground, to have more precise evidence concerning the party's cultural and religious norms and the manner and the extent to which those norms impacted non-consummation of the marriage. The court granted the annulment. I wanted to do this case because it's quite interesting from Judge Doulis. I quite like Judge Doulis. I find Judge Doulis quite thoughtful in her reasoning. But anyway, this was FMEP going after BB. And BB would order to pay child support in July 2005 in the amount of $670 a month on imputed income of $48,000 a year. At the time of this imputation, BB was in jail. And over the 16 years, really, BB only earned $48,000, I think, once, or didn't earn that amount much at all. And the mother never received any child support from BB directly. It was only when FMEP could garnish, usually from like the federal government, right? FMEP chased BB. I mean, if you read the case, there's like, this hearing, a whole, like 2 pages of it. BB had sporadic income due to his intermittent incarceration, his addictions issue, and his poor health. He hadn't worked in 4.5 years. He had carpal tunnel syndrome, and he couldn't return to work as a welder until he had surgery. So he had multiple convictions, and for which he was incarcerated. He also had fines and restitution. He owed ICBC $120,000. He struggled with addictions his entire life, adult life. He was alcoholic. He used cocaine, then heroin. And I talked about his carpal tunnel syndrome. His only source of income at the time of this enforcement action was income assistance. He owed $37,000 in child support, and of that, $13,700 was interest. FMEP wanted his income to be imputed to $25,000 and sought that he pay $400 per month towards the arrears. And, hammer, if he failed to make a payment, he was to be incarcerated for 5 to 10 days for each missed payment to be served consecutively. Imagine that, each missed payment. Every single month, add on 5 to 10 days, because there's no way he could pay, right? There was no way he was in position to pay. And that's what Judge Doulis found. She said, look, and the big thing, this is why this case is important. She took note of the overrepresentation of Indigenous people in the prison system. She says, hey, I know the FMEP, that whole system isn't the criminal code, but we need to apply the same principles here because they're seeking incarceration for default. So we need to, the court said, Judge Doulis says, you need to apply the guidelines in the criminal code, section 718.2 on sentencing principles, particularly in relation to Aboriginal Indigenous people, and the Supreme Court of Canada's decisions in Gladue and Epile, right? She said the courts can take judicial notice of the broad and systemic factors affecting Indigenous peoples generally, and specifically to the person subject to incarceration. She found that the systemic and background factors affecting Indigenous people in Canadian society have likely impacted BB. I think she says it likely because I don't think there was evidence that was explored with BB on this issue. Judge Doulis noted the difficulties faced by BB arise at least in part from transgenerational trauma and substance abuse arising from the Indigenous people's involvement in colonialism, displacement, and residential schools. She was cognizant also the impact of putting BB in jail on his former partner, the mother, and their children who are now adults, as they're also Indigenous. The judge wasn't convinced that imprisoning BB for non-payment arrears would improve their lot in life. She noted that BB appeared to be on a rehabilitative path, and she didn't want to derail that by imposing a punitive sanction. So Judge Doulis was prepared to order that BB pay $100 a month to FMEP on arrears, but she was not prepared to reinforce the order with a jail sentence in default. She said, come back in 4 months and we'll take a look. I don't know what happened in 4 months. Anyway, I think that's a very interesting and important case. And I don't usually find FMEP cases that interesting, but that's one. We are at 2:30 now. So yes. I should probably let you all go. Oh, I wanted to talk about property. I'm just kidding. Hey, property. Just one last thing about the rules. You remember before you could file in any court? You could start an application in any provincial court. There's a case called, it's in the slides, AKB and ADW, but Judge Gouge on the island. This was a mom who, the mom, dad, and young baby 3 were living in Vancouver. She went to Duncan and started a proceeding there, got a protection order. And then the father was contesting it in Duncan, and Judge Gouge says, wait. Rule 7 of the Provincial Court Family Rules, it's new, says, no. If you have an application, you're seeking orders related to a child, you have to file in the registry that's closer to where the child resides. And this child was residing in Vancouver, right? So Judge Gouge punted it back to the registry in Vancouver. So it's an important case just because I didn't realize that until I read this. I read the rules, but I don't really read the rules. So this helped me go, oh shit, I better read the rules. So just wanted to point that out to you. Anyway, lovely to see you all. I hope you have a great rest of your conference. If you do have any questions, you're always welcome to call me. You know how to find me. You're always welcome to email me. And yeah, lovely to see you on next year in person. I'm open to different themes, so let me know what you want to do. Let me know what you're prepared to do.
Thank you, Agnes.
You're very welcome.
Thank you, Agnes.
Thanks a lot.
Thanks, everyone.
Bye.
Bye.